বিন্টুদা এখানে রেখে দিলাম। হ্যাঁ, সুপ্রিম কোর্টের মামলাটা চলছে তো ওখানে থাক।
State of West Bengal versus Committee for Protection of Democratic Rights.
Well said.
Para 70 and 71. The last two paragraphs. I'll just read out.
Mami রাখছে mami রাখছে mami ও mami এইখানে রাখছে ম্যাডাম রাখছে
brother.
So in fact, there could not have been any finding of criminality. No, there is.
The CBI investigation had been directed to continue by our court itself.
That's right.
So there was a CBI investigation going on in regard to the criminality in the main
It's the main matter about those appointed.
which would also include the waitlisted candidates.
Yes.
Now, if that was so, then is the High Court not really only in this direction? The High Court is not in furtherance of what we have directed ourselves.
No, your doctrine directed is continuance of CBI inquiry, which was already going on with respect to those who have been appointed, namely rank jumping, namely outside the sanction post, more than the sanction post, they were being appointed. Those who were where about this OMR sheets was problem. So they were investigating the selection process.
Same selection process, right?
But nothing has been appointed. Nothing has happened. Well, where is the question of criminality if the government passes an order which remains on paper? So what can be an attempt to commit what crime, my lords?
All right, we'll
So that's the issue, my lord, which I am raising. And moreover, my lord, lordships have said apart from this judgment that there has to be compliance with natural justice. No pleading, no issues. Where is the hearing going on this aspect? Focusing on this aspect. Then the state should have been put this issue directly, not whether, why should not this CBI inquiry be directed? Then all these arguments, Lord, we would have placed before the High Court. The High Court would have considered these questions, these aspects.
Thank you. Just add submission for your just consideration.
Admittedly, it is a fact that a single judge of the Honorable High Court was seized of the cabinet note issue. This matter was neither argued, nor were we ever called upon before the DP, nor was the subject matter of the matter pending before the division bench, the cabinet note at all. But more importantly, please see, where does the impugned order go completely wrong? Kindly have page para 265 on page 226 of the impugned order.
Ara?
265.
What page should that be? Do you have a
Page 226 of the paper.
257.
PDF 257.
Yes.
Manoj has that?
Yes.
The state government, therefore, has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally would not be determined with exactitude. They had resolved to create supernumerary posts to accommodate illegal appointees. In other words, state has reserved to expend taxpayers' money to accord sanction to an employed secured dishonesty. There is no appointee as far as the waitlisted candidate is concerned. They completely mix it up with the earlier recommendation which your lordship stayed of the SSC. This was a cabinet note prepared on waitlisted candidates. No one had been appointed, so there were no illegal appointees. Now read this, my lord, with para 355. Please read this with para 355 on page 277. EDF 308 minus.
The issue of whether the reference should be made, this investigation should be made by the CBI or not.
Instructed to say subject to correction. I am instructed to say this was never an issue before the division bench, never argued, never called upon to answer. It is pending before another judge. It's pending before the single judge in Calcutta High Court. But let's kindly have para 355 of the impugned order, page 277, and PDF 308.
Suggesting what would you want to us to see, Mr. Paul?
Para 355 on page 277, PDF 308. What's happened?
Yes.
Investigation by CBI with regard to the creation of supernumerary posts is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by the SSC for state-funded schools, knowing fully well that such appointments are obtained beyond panel and after expiry of the panel at the bare minimum. So the state cabinet, all departments, the entire memorandum which is prepared under the state rules. And I just showed you, Lordship, there's a whole rule, there's a whole procedure, rules of business. The manual concerned of the state government under which cabinet notes are prepared, the administrative department, legal department, finance department are all consulted. And then a cabinet note goes up to the cabinet. So you are today saying, firstly, you get it wrong, you talk about illegal appointees. These are waitlisted candidates. Secondly, you today want to include criminality. And look at the dangerous precedent it sets that in every matter of these kinds, the entire cabinet, the whole process, everyone will be subjected to a CBI investigation. And most importantly, now see, my lords, in this background, paragraph 363, subclause 8, what is the direction given? The direction given is on page 363 at page 281, clause 8.
Yes.
CBI will undertake further investigations with regard to persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointees. If necessary, CBI will undertake custodial interrogation of such persons involved. So, my lords, today, as your lordships are well aware, with the entire West Bengal Secretariat Manual, Chapter 6, rules of business, officers involved, departments involved, everyone who prepared this, including the state cabinet, the Advocate General, everyone will be subjected to, because the legal department, the finance department, everyone is involved. The approval of the legal department was taken. Everyone will be investigated by the CBI and if required will be taken into custody. And please see 118, what were the issues framed by this court in this matter, my lord, because your lordships asked me a pertinent question. Was it my instructions were never argued, never raised, not the subject matter, but the issues are called out in para 118, PDF 191, para 118.
Yes.
The prevenient enumerated rival contentions have been delegated the following issues for consideration. Does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? Are the writ petitions maintainable at the behest of unsuccessful candidate writ petitions subsequent to the expiry of the validity period of the panel? Can appointments be made subsequent to the expiry of the validity period of the panel? Is the certificate dated so and so valid and admissible in evidence? Should the OMR sheets available in the seized hard disk be uploaded in the server of SSC to compare with final list stored therein? Should any reliance be placed upon the data stored in the seized hard disk to terminate the services of any employee? Can the recommendation be withdrawn by SSC without hearing the appointee? Whether revocation of recommendation under Rule 17 by SSC is valid or not? What relief or reliefs are the parties to the appeals and repetitions entitled to? Manoj, with respect, apart from not being an issue, it's an extremely dangerous precedent that we are setting. What are we saying? That a court without an issue being raised, discussed, today orders a CBI inquiry if required with custodial interrogation, right going till the cabinet. With no proof, nothing, no suggestion of any criminality, and everyone gets roped in. Now the whole cabinet process of decision making, my lords, in a parliamentary democracy, where do we go? Look at the far-reaching consequences of this direction which is being given. Apart from getting it completely wrong at the cost of reputation, talking about illegal appointees rather than the waitlisted candidates, where the cabinet note says there may be potential irregularities. Tomorrow, let there be no vacuum. Let people be taken from the waitlisted, subject to outcome, subject to court. The SSC recommendation where they took permission of the court and where they wanted to apparently withdraw it, ultimately they refused them to withdraw and ordered a CBI inquiry. That also your lordship state. But this is much graver.
Yes.
So, Manoj, our respectful submission is that A, there was no occasion, no issue, no argument. But even on a principle of law, my lords, can such a far-reaching direction in the manner it has been given, be really be sustained, apart from the fact that here no one argued the point? I'm extremely grateful, my lords, for your lordship's kind consideration.
Who would be answering this petition?
Manoj, our only other issue
Mr. Gupta, you're also on the same side?
Yes, I'm for the commission.
Yes.
Our only other consideration will also be this, we lordship to keep in mind, that today it's not even CBI's case that 25,000 illegal appointments have been made. In one rush to cancel everything, my lords, creates and leaves the state with a situation where there's a huge vacuum, the teacher-child ratio, various other requirements under that, everything today goes for a 6 because suddenly en masse, you say that 25,000...
That's on the second issue, whether segregation is possible.
Yes, that's a segregation. Only? Yes. That is the other one which we are extremely concerned about. Very grateful.
Yes, Mr. Gupta.
Yes, my lord. Just 2-3 facts, my lord. First of all, my lord, the advertisements are given out, my lord, in 2016 for this batch of recruitment. There are 4 batches, my lord, 4 categories of persons to be appointed. First one, my lord, is class 9 and 10 teachers, assistant teachers of class 9 and 10, for which there is a rule of 2016. Secondly, my lord, teachers of 11 and 12, for which also there is a separate rule of 2016. Similar rules. Thirdly, my lord, Group C and Group D employees. Clerical and, my lord, subordinate. most of the appointments, my lord, were completed in 2018.
Which is the fourth category?
Fourth category is, my lord, C. Third category is C. Fourth category is D. Group C, Group D. Clerical and subordinates. Non-teaching, yes. My learned friend is right, my lord. The third and fourth categories are non-teaching.
Yes.
Now, my lord, the appointments were given on various dates after counseling. My lord, mostly in 2018. And my lord, they started working from 2018. In 21-22, my lord, the writ petitions started coming in. By this time, the panels, validity of the panels had gone.
How long was the validity?
My lord, different dates, my lord, but 1 year with my lord, 6 months extension possible in certain cases, and my lord, in some there is no date, my lord. There is no, my lord, period mentioned. Now, in 21-22, my lord, these matters were brought in, my lord. There was a series of orders by the learned single judge, some of which came to this honorable court, my lord. And one of those matters, my lord, one batch, by an order of 9th of November 2023, was, my lord, remanded, but not to the judge, but, my lord, to a division bench. Now, this did not cover, my lord, the whole batch of matters which were before the High Court. It covered some. This went to the division bench. The division bench has taken this, my lord, stand. This is the judgment, which is before your lordship today. Now, my lord, this is the first appeal. The learned single judge did not dispose of the matters. Before that, your lordship said he will not dispose of these matters. It will be disposed of by a division bench. So, my lord, the division bench disposes of this matter for the first time. And this, my lord, is the first appeal we had. Now, what is the substance, my lord, of this order? Your lordship has seen, my lord. First of all, the issues, if your lordship sees, and then I'll go to the directions. The issues are at paragraph 118, page 187 PDF. And my lord, on the side, I'll put the answer also. Now, just see, my lord, does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? This was because this hearing was set up pursuant to a particular order of this honorable court, which dealt, my lord, mostly with the OMR sheet problems. And, my lord, the learned Chief Justice was directed by your lordships to place it before a bench. Now, the learned Chief Justice, my lord, passed an administrative order, and, my lord, it was placed before this division bench. The first contention was that this means that a particular batch is before this court, not everything. Right.
Yes.
But I'm not making too much of an issue with regard to that, because the court said let us treat it as a PIL. But, my lord, the result is, my lord, that there are many matters still pending before the single judge or this very batch. There are many matters pending before the appellate court, and there are several matters pending in this honorable court. And now, my lord, there is an actual conflict between orders of this honorable court and this judge. My lord, I am only pointing out, my lord, that it is not possible, my lord, for this matter not to be heard of. Notice, my lord, and your lordship must hear it out. My lord, that's, my lord, where I am going now. Now, then, my lord, that was the first one. Answer is yes. Taking it up as a constitutional court, it's a public interest litigation, so the maintainability will not come in the way. Then, my lord, can appointments be made subsequent to the expiry of the validity period of the panel? Now, my lord, this is not investigated at all. In one particular line, my lord, it is just said casually that it can't. Now, my lord, there is a factual background to it. Sometimes there is a rule backing it. Sometimes there is an executive order backing it. And there is a reason for, my lord, the extension. Because, my lord, for various reasons, my lord, the actual counseling had got delayed. And, my lord, there was COVID also. So, therefore, that is no. The answer is no. 4, my lord, is the certificate dated 19th of September 2022 valid and admissible in evidence? Answer is yes. And I'll give you a lordship.
Gupta, you are paying for the commission, right? You
Yes.
didn't create these supernumerary posts. It's really the state of
Supernumerary post is one small aspect of this matter, my lord. Very important, no doubt. The state is concerned with that, my lord. But the real substance of this matter, my lord, is the cancellation of the my lord appointments. I will come to, my lord, the directions now to show your lordship, my lord, that this kind of a far-reaching order, which affects, my lord, a huge number of people, which is blatantly unfair on the face of it, because people who have actually taught for 6 years are being told that they have to give back the money that they have been paid as remunerations.
We are now arguing the broader aspects of the matter.
No. These are directions. I'm asking for stay. I'm asking for notice and stay, not broader aspects.
Now, when did you destroy the OMR sheets? Is provision as to how long the
No, there
OMR
is
sheets
specific
are?
provision. There is specific provision. We are supposed, Rule 21 is there. We are supposed to, my lord, ensure that digital copies are maintained. Digital copies were maintained. Of course, my lord, it has been recovered from, my lord, an employee or an ex-employee of the concern which was asked to scan it. Now, regarding that comes, my lord, the fourth, my lord, question or issue. That gentleman has given it to the CBI with a certificate. My lord, the court said there should be a certificate under 65D of the Evidence Act. So,
But you gave the scanning work
yes,
to that NISA,
yes, correct.
right? Now NISA appoints that data scan tech.
My lord, yes.
Your
We don't
chairperson,
know that, my
your
lord.
chairperson says I'm not even aware of the appointment of data
That's
scan.
correct, my lord, but this is not an outsourcing. NISA retains full control, my lord, who they are sending to my office to scan it actually. Whether it is an employee of NISA or whether he is using some other person to do
You appoint NISA without even a tender.
No, my
You
lord.
just sort of
Now,
award the contract to NISA.
all this, my lord, is the kind of, my lord, overriding statements which are there in the judgment. NISA was appointed by way of a limited tender, in the sense, my lord, that several organizations were asked to quote, and this was found to be the best quote. 4 organizations were asked to quote. Your lordships have said as early as 1986 in Sachidanand Pandey that it is a valid method by which the government may, my lord, farm out work. There can be a limited tender. It's a very specialized job. It did not require a global tender, my lord, according to us. And, my lord, the whole thing is, my lord, that they have come. They took the contract. Who actually went into the office and scanned it, my lord, was their concern. We have no relationship with data scan. Now, so therefore, my lord, ultimately,
Now the OMR sheets have been destroyed. You say that because under Rule 21 they had to be destroyed.
that's right.
But even the mirror images on the scanned sheets are not in the SSC.
That's right, my lord. It was, my lord, being accessed from NICE, NYC. It was being accessed because, my lord, people would come with queries. After the date of destruction of OMR sheets, when people came with queries, we took the data from that organization and gave it to them. Now, my lord, just for a moment, my lord, my stand on this OMR sheets digital data is, my lord, that we have proceeded on that basis. When the CBI obtained the digital data, and, my lord, the court said you should back it up with a certificate under 65B, the commission thereafter proceeded on that digital data. So, my lord, it is true that there are many parties before your lordship who are arguing that 65B has not been satisfied, so therefore this digital data is not to be looked into. But, my lord, the consequence of not looking into it is that then there will be no evidence to show that there is a discrepancy between OMR and what is on the final marks in our server. But we are not saying that. We are saying we have accepted those and we have looked into it, and based on that, my lord, the segregation is to be done. So, my lord, 65B, my lord, is something which will be argued by other persons. The commission, my lord, has so far actually said, all right, very well, we will go by what the CBI has given us. So that is, my lord, issue number 4. May I show, my lord, the 5th issue? Should the OMR sheets available in the seized hard disks be uploaded in the server of SSC to compare with the final list stored therein? Answer given by court is yes. And, my lord, apart from, my lord, the question as to whether this should be made available to the public in general, 22 lakhs, my lord, or whoever is interested, we have no grievance with, my lord, uploading it and comparing it.
Now, if
Yes.
you go back to now para 335 at PDF 298,
Yes, ma'am.
where the court sums up what it has found.
Yes.
Let's just read para 335 at page 298. This is
Yes.
your card. The evidence placed before us have established the following illegalities in the selection process.
Right.
Now,
335.
Yeah, just read.
I'm going to place this. The evidence placed before us has established the following illegalities in the selection process. SSC has appointed an agency, NISA, for the purpose of scanning and evaluating OMR sheets by a closed-door tender process in violation of 14 and 16 of the Constitution of India. Answer is no, because Article 14 and 16, your lordships have said, allows limited tender process. The judgment, my lord, and there are several.
How many bidders were there?
My lord, there were 4 bidders.
Why did you not issue a proper tender? You're dealing with something as sensitive as the appointments to the SSC.
My lord, your lordship may, your lordship may come to that conclusion. I'm not saying. Today we are arguing for notice. It has not been considered. The court says closed door. There is, my lord, a legal concept which is missing in this analysis, and that is of a limited tender. A limited tender, my lord.
Let's first read
Yes,
the para.
right. I'm just answering as I go along, my lord. If your lordships will permit. Otherwise, I'll read first and then.
That's okay.
Number 2 is, my lord, such agency has engaged another agency, namely Data Scan, to scan. Now, well, this is not illegal, and we are not aware. They are getting their job done. They have not.
Surely the Staff Selection Commission must introduce a condition that you will not hand over this to somebody else.
No, my lord.
Because these are matters of confidence, of trust.
Most certainly it is a matter.
You have to say that, look, you will do it yourself, otherwise don't bid for the project.
My lord,
The fact that you did not prevent outsourcing shows that you had just turned a blind eye to the whole
I'm not-
sanctity of the process.
my lord, no, this is not a case of somebody coming and saying, I'm introducing a new person. This is, my lord, NICE doing its job, and I am not, my lord, aware that there is another organization which has got involved in it. This didn't come to our attention till the matter was going on. So
Right.
therefore, my lord, as far as we are concerned, my lord, NICE executives were in our office doing the scanning. My lord,
Now just think, we'll continue 3, 4 and 5. We'll just
now 3. Although scanning was done at the office premises of SSC, it is claimed that SSC has never engaged Data Scan Tech. Naturally, my lord, we are saying the data scanning was done by NICE. Now, NICE says that the actual operative.
But when data scan takes employees enter your office, surely you know that somebody else is entering my office to do the
Not
scan.
disclosed, my lord, not disclosed.
But if your staff is there, your staff is supervisory. For instance, we have scanning agencies in the Supreme Court.
Yes.
That scanning agencies, people come here for the purpose of scanning. If they induct somebody else, it's our responsibility to know if there's a third party which is entering into our premises.
Yes.
Because our supervisory control, our officers are doing the supervisory control over who is the authorized agency who is entitled to do the.
I'm very sorry, my lord. No third party is entering.
Our staff cannot say, well, I don't know who else came in.
I know who came in. They came in as NICE employees. There is no indication that the person concerned was somebody else and not NICE. That's not meant to be my lord of fun. Now, my lord, so my lord, data scan, my lord, in my respectful submission is a red herring because the work is given to NICE.
What follows?
Yes,
Four.
right.
SSC.
Four. SSC has destroyed the original OMR sheet ostensibly with scanned mirror image thereof being preserved in its server. Now, my lord, destroyed in accordance with rules, my lord, we say, your lordship may consider that. That's all. CBI did not find any scanned mirror image in the server of SSC. That is true. Because, my lord, we relied on, my lord, the person and the NICE gave us the data at all times. Even today, my lord, NICE is giving the data. Whether, my lord, it is from an ex-employee, whether it is covered by a 65B certificate, all those are questions. But, my lord, the data which the CBI is using, which I am using, all that data has actually come from NICE. Now, my lord, C6, OMR sheets have been destroyed without scan. So, my lord, therefore, there is no.
Now, when you destroy the OMR sheet,
Yes.
it was the Staff Selection Commission's duty to ensure that the mirror images are preserved in the server.
So, my lord, if the.
Now, there is no mirror image in the server at all.
So, my lord.
So, your case is that, look, I was duty bound to destroy it after a certain stipulated period. But equally, it was your responsibility as the SSC to keep the images, the scanned images in the server.
My lord, fair enough, my lord. The question that you
Why
got.
are they not being preserved in the server?
But, my lord, it is being preserved.
Where?
In NICE.
No, but CBI doesn't find it in
No.
your server.
No. The digital information is to be preserved.
But in your server.
Now, it has not been found in my server, but it is found, my lord, where it was taken.
But it's worse because NICE at the highest is only an outsourcing agency. Imagine your entire data is now found in the server of an outsourcing agency.
So now, my lord, would your lordship,
Can there be a greater breach of security protocols?
my lord, would this be enough, my lord, to set aside, my lord, the employment of 25,000 people is the question. Now, these three paragraphs, my lord, are actually one point itself. One point.
Then of the whole process.
So if CBI is proceeding on that basis, CBI is taking that data only to prosecute.
Now, if these were destroyed,
Yes.
look at 7.
Yes.
SSC had provided scanned OMR sheets to RTI applicants in the year 2018 till 2020.
Thanks, my lord, from NICE. From NICE.
So that means you knew that the entire data was maintained with NICE.
Of course I did. Not data scan. It was not maintained with data scan. It was maintained with NICE.
What was maintained with NICE?
The data, the entire data, digital OMR data.
How can that means that you are the statutory body? You allow the entire scanned data to be maintained by an outsourcing agency. It's only a labor provider to do the scanning.
But today, my lord, that very data is being used in a prosecution. So, my lord,
Maybe, but today we are looking at your breach of your statutory.
Well, my lord, your lordship may look at my breach.
Yeah.
I am only going to show your lordship, my lord, what is the actual.
You can't say that, look, NICE took it away. You are responsible for maintaining it. It is people's data.
Please don't misunderstand. I am not, my lord, blaming NICE. I am not blaming NICE. I am even accepting, my lord, that without a 65B or not.
Now see what follows.
Well, just-
Means higher than the declared.
My lord, if I may just add one thing here, my lord. My lord, if I may just add one thing, my lord. This very data
In
Let-
7, they say
I'm not.
SSC.
I'm not running away from a single clause. Just let me finish this submission, my lord.
Yeah.
That the very data that is being used by this court in this judgment and the data which will be used in the prosecution by CBI has completed its investigation. It has said so to the court that we have completed the investigation. Charge sheets have been filed. Now, my lord, that is going on. Now, question is, my lord, this very data is going to be looked at for both the purpose of this judgment and that. So, my lord, the authenticity of this data is not going to be under challenge.
Now see 7.
Yes, now 7. SSC has provided scanned OMR sheet to RTI applicants claiming that such was from the database, although CBI did not find.
So
We are saying that,
you have responded to RTI queries
Yes.
saying this is from my database.
I don't know whether it said mine.
Yes.
Just said database.
No, from your database. And now it's come to light that this is not in your database at all. That means what you were saying to RTI applicants that look, this is in my database.
So,
That is incorrect. Look at the Staff Selections Commission's modalities of conducting it, Mr.
my lord, it may be, my lord. It may be, but that same very data is being relied upon. Today, this judgment would go if you take away that data. It will have to be set aside. Because, my lord, in one chapter,
There is no data at all.
suppose there isn't, my lord. Suppose there isn't. Then what will happen to this judgment?
Then the appointments have to go.
My lord,
Because either you have the data.
yes.
If you don't have any data, we understand that OMR sheets in the physical form, you can't maintain
Yes.
them in eternity.
Yes.
But then two things. You are duty bound to maintain the underlying documents in a digitized form.
Yes.
So now today with digitization, it obviates the requirement of all that storage and everything.
Truth.
Now you say that look, I don't even have the you provide RTI responses saying this is from my database. Now it's obvious that there is no data in your database.
All right.
That
All I'm saying is, my lord, that I am
NICE is the
saying.
only agency. NICE appoints data fintech.
No, my lord.
You are unaware of the fact that your service provider has further subcontracted the service to somebody else.
My lord,
Surely
your
you have to
lordship
keep-
may hold us.
You had to keep supervisory
My lord,
control.
Very well, my lord. I am not, my lord, on that. I am saying that the very same data which your lordships, my lord, are doubting is the basis for the CBI prosecution and this judgment. So if your lordships, my lord, are not to look into that data, my lord, then this whole judgment has to change. It may still lead to, my lord, investigation, but it cannot be, my lord, what is happening now.
Now, appointments
Yes, my lord.
higher than the declared vacancies have been given in respect of all 4 categories.
Appointments higher than the declared vacancy have been given in respect of all 4 categories.
Appointments given to persons who are not even in the panel.
Yes.
Appointments given to persons who submitted blank OMR sheets.
Yes.
Appointments given to persons after expiry of the panel.
Yes.
Persons placed lower in rank had been given appointment in preference to persons placed higher in rank in the merit list.
Yes.
Merit list containing marks obtained by respective candidates have never been published.
Yes.
Counselling had been held subsequent to the expiry of the panel.
Yes.
Total beneficiaries of the illegalities are yet to be identified and rendered improbable given the stand of SSC board in the state. SSC had applied for permission to create supernumerary posts to accommodate the illegal appointees, and recruitment rules governing the 4 categories had never been adhered to either in letter or...
No, that last one is a conclusion.
That's it.
Now, my lord, I have made a chart. We have exact data as to which category which appointment falls into. And, my lord, we are not defending. We are not defending appointments which have jumped the list. We are not defending those appointments which have come outside the panel. We are not. We are saying, my lord, that the 16,000 of this 24,000, 19,000 of this 24,000 are not tarnished by any of these clauses. And it is very easy to demonstrate. It is very easy to demonstrate. We have prepared the chart. The chart will show, my lord, that out of this 24,000, 19,000 were appointed from existing merit lists in accordance with the merit list, within vacancy, within time, everything. And my lord, we were the ones who came forward and gave that data to the court, saying that these are not certain my lord, appointments cannot be justified.
So according to 19,000 are within the merit list.
At least, my lord, that is our rough, my lord, estimate at this point of time. And we told the court that we are prepared to do this exercise all over again. Please see one paragraph only of the judgment. My lord, page 99. I think your lordships are looking at another SLP, but I am on, my lord, paragraph 33. My pagination, because I'm in 10.1, may not match. But look at 33. In fact, my lord, 124 PDF. Finally, পৌঁছতে পারবো। Which is recorded in the judgment.
How do you displace these findings, Mr. Gupta?
Milord, I am not displacing all those four categories, Milord. I have segregated now.
Look at it's a systemic fraud.
Milord, just look at the directions then, Milord. Is this fair? Look at the directions now.
And ultimately, Mr. Gupta, what happens is this.
Yes.
Today, public jobs are so scarce
Yes.
and so valued
Yes.
that if the faith of the community in public employment goes,
Yes.
then nothing remains. Because today, public jobs and public employment is extremely valued.
Yes.
It's a source of social mobility for people coming in from the lower strata.
Yes.
People only aspire that, all right, my daughter and my son will get a government job. If this is the way, I mean, we are virtually purloining public employment. What remains in the system?
But Milord, your lordships have said,
How do you displace these findings?
Milord, your lordships have said so in several judgments that if it is possible to segregate, we will not set aside the panel. I'll just show you, lordship, just two, Milord. One is your own judgment.
Where I think Madhya Diwan had appeared.
Yes. And I'll show you, lordship, one other paragraph, Milord, from another judgment of the same year, 2021, which says
But
that even if...
interestingly, that was the case when the entire process was set aside.
Yes, correct.
Yes.
But here, your lordships have also had occasion to say that even if there is a small possibility that it is possible to segregate, we will explore that possibility. Because on the one hand, what your lordship is saying is right, that people, my lord, have an expectation of public employment. On the other hand, my lord, these very persons will be on the street.
But you have nothing to show that this is the data which I have maintained.
My lord, I am sorry, my lord, if this
Where
data
you
is
have,
to be...
what you have within your system, any traceable record to show that this is the data I have maintained.
My lord, the prior chairman of this organization is being prosecuted on the basis of that data. Surely, my lord, if your lordships were to cast doubt on that data, then no criminal prosecution can be based on it. My lord, let us, my lord, proceed on the basis. As far as I am concerned, the other my learned friends may have some other argument, but let us proceed on the basis that the digital data which the CBI has obtained is going to be relied upon. It is another thing that it has come from the custody of the outsourced person. But it is being relied upon by a law.
Anything
In
else?
para 30,
We'll have to hear the others also.
yes, I've just give me 2 minutes for it. In para 33, we have said that we can do the job again. So, my lord, it is not correct to say that we did not offer to do it again. Para 33 has recorded it. The second point is, my lord, para 240 is the only statistical analysis of page 229 PDF, para 240 of item 10.1.
29.
229, yes, sir. Paragraph is 240 of the judgment.
1 second, that is the wrong.
No, that is because, my lord, your lordship probably has 10. Paragraph 40, my lord. Page 229 is in 10.1. 240, yes. Now see, my lord.
Para 239. Para 240.
240 is a chart. I'm showing it, my lord. Why is my learned friend getting agitated? My lord, just see, my lord. Alleged irregularities in percentage 8.5 for assistant teachers of 9 and 10, 14.7 for 11, 12. The other two are very high. Now, the problem with this order is, my lord, to bunch and put everybody in the same basket. Second proposition, my lord, this is the data taken from, my lord, the CBI record. Now, are we to rely upon it or are we not to rely upon it? That's the question before your lordship. If we can rely upon it, my lord, segregation is possible. If we are not to rely upon it, then, my lord, there is difficulty. But then, my lord, the judgment doesn't stand. Some other recourse has to be sought. Even then, my lord, your lordship will have to go into the question. My lord, just 2 more points, my lord, I'll sit down. Will I? A very important point. This segregation has to be done inevitably even under these directions. Just look at direction number 4. I, of suppose, my lord, we are submitting that this is an unfair order. Even if, my lord, everything is correct, it is still unfair to say give back the money which you earned by teaching. But C4, persons who have been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments, must return remuneration with interest. So only 3 categories have to remand it, give it back, refund. So the segregation has to be done. And upon segregation, there will be a large group of people who are not required to give up the fund, the payment. Now they will be faced with the situation that they have lost a job, but they are not held responsible. There are 2 more things, my lord, I'll sit down. Now, my lord, this 8th direction, or the 7th direction, 8th direction your lordship has already stayed. The 7th direction, further investigation by CBI in respect of all the 4 cases, meaning the 4 categories. My lord, on 9th of January 2024, a comprehensive report was given by CBI saying that they have completed investigation. And final charge sheet has been filed. Now, my lord, by what process, my lord, can the writ court say you reopen that investigation now? My lord, that statement by the CBI, my lord, is contained in 9/1/2024, page 743 PDF of, my lord, item 10.1. Last submission. Yesterday, my lord, we have sat and found out various categories. As I told your lordship, my lord, the categories include those who have been recommended as per merit list and some who have been appointed pursuant to orders of court. So these 2 categories, my lord, should not be, my lord, subjected to, my lord, this cancellation is our submission. Yes. Secondly, my lord, as far as the period of the merit list, validity of the merit list, my lord, that we wish to defend. Because, my lord, there are, in some cases there are rules, in other cases there are executive orders for stated reasons. We wish to defend that beyond the period. Yes. We do not wish to defend, and we wish to segregate persons whose OMR data, digital data, does not match our server. We do not wish to defend persons who were appointed from the waiting list, not in accordance with rank. Rank jumping is the phrase, my lord, used here. Summarize. Yeah. We do not wish to, my lord, support anybody who is not in the panel and has got appointment. And my lord, there are some people who have been appointed without our recommendation at all. Those also, my lord, we are not defending.
Yes.
My lord, I'll just give your lordship the judgments. Your lordships are aware. 2021, 4 SCC 631 is your lordship's judgment. 4 SCC page 631, paragraphs 35 and 55.
Yes.
And 2021, 7 SCC 613, 7 SCC 613, paragraph 73.
Yes.
Which says, my lord, that if it is even possible, then one should prefer to segregate rather than cancel the whole. So, my lord, this is my support.
Yes, Mr. Twenty.
Lord, may I please be excused, my lord? If your lordship requires, my lord, I'll come back.
SSC.
Lords, I appear with Mr. Ghosh for the West Bengal Board, my lords. The Board of Secondary Education.
Yes.
My lords, we are the ultimate beneficiaries of the process because we get staff entirely through the Staff Selection Commission. And whatever they recommend or whoever they recommend, we normally appoint. Lords, today, my lords, in the state of West Bengal, I believe there are about 132,000 teachers, and this judgment affects about 17,000 of them, at least. Almost 18,000, I'm told. So that, my lords, is almost 1/6, because this also is a specific category of teachers from the 9th standard onwards. My lords, there is nothing in this judgment about great irregularities on our part, so there is nothing that I wish to open further. I would join in the request made by council before me, my lords, that where segregation is possible, in the interest of continuing education, and also in the interest of the state, that it should have reasonably trained students, teachers. So
Bear that in mind.
they have had 6 years of experience. Now, what will happen, my lords? If these people, if we lose a whole chunk or a whole generation in between, we will not have senior headmasters, we will not have senior examiners at a later stage. Right?
Let me bear that in mind. The
Yes,
due
ma'am.
consideration will be. Thank you, Mr. Agri.
Your lordships will also bear in mind the fact that many of these people did not get any notice. Those only those where there were specific allegations, they came to court. They had notice, but it was not as if there was a general notice.
Thank you, Mr. Agri. Yes, Mr.
Just one more request, and this is what I. Sometimes, my lords, when there is a headache, you don't cut off your entire head. That's the argument.
Yes, sir.
Our case is slightly sui generis, if I may use that expression. For this reason, that we were people who were working from 99, 2007, 2011, 2001. What had happened, Lord, just let me explain. There was earlier a zonal system of appointment of assistant teachers. So the zones were such, Lord, the rules were that if you are in one zone, you can't be transferred. So many of these assistant teachers were far away from their homes, in the big state of West Bengal. So they got an opportunity in 2016 by this advertisement that they could participate in the selection process. Now, by this participation, quite a few of them have been able to get appointment or posting in a place which is there, because now it has become centralized. From 2016, the whole process became centralized for the entire state. So therefore, because the entire state became one, so persons wanted to take a try that if I can be nearer, assistant teachers as they are. So these are persons who sat, they were given no objection to sit for the examination, they sat for the examination, they were found successful, and thereafter they were appointed, they were given continuity of service, their pay was protected, and their service books remained the same. Now we got notice of this one.
How many of
We are 367 persons.
Who were appointed since?
So we have placed a chart below the state number 733
Of?
in my item 17.6. Item 17.6. The chart is at page 733 of all the 733 is of all the 367 people. One person is due to retire next year.
17.6?
मेरे पास तो है ही 17.6.
17.6.
Exactly.
Its name is Atanu Chaudhary.
Annexure B40.
Annexure it's B42. B42.
First name is
T40. I'm a black. Sorry, it is B40.
first name is Atanu
Yes,
Chaudhary,
Atanu Chaudhary, my lord.
and the internal page is 733.
766.
733.
Yes, my lord.
Right.
Wait, that's
Okay.
Yes, much obliged. So the first name, if your lordship just have a look. He was first person was appointed on 11/10/2007 in the 5th column, my lord. Your lordship will find first date of joining service 11/10/2007 in Purulia. That was the first district.
as per the zone. Now he has joined again on 26/9/2018 in Hooghly. And his permanent address, if you lordship see the fourth column, was Milord in Chandan Nagar, Hooghly. So they were given permission to participate. They left their lien in the old job. And they have forgone that job. They have joined here and they have been working since then for the last 6 years. If your lordships were to see, there are two examples.
Which is your SLP?
Milord, my SLP number is 17.6. It is, Milord, I have an 20729 of 24. 20,729 of 24 is my SLP number, diary number. SLP.
Covers totally 367 persons.
367%.
When they were appointed earlier, they participated in this and they were given continuity of service.
744 is somebody who was appointed in 1999. 744, I have given that, shown that, I can show that example. And serial number 131. And he is due to retire next year. So he was appointed Milord on 8/3/1999. And he is due to retire now. So these are, I am representing those set. Now, we got notice of this in November 23 before the High Court. We filed 2 applications before the High Court. The applications are been taken note of, but no orders are passed. If your lordship would like to see that paragraph, it is in paragraph, Milord, page 154, paragraph number, Milord, 108. This is all that is stated. We have annexed the copies of these applications also, with our especially. But I am showing this paragraph of the judgment from the first paper, State of West Bengal paper.
Yes.
So they only note that these applications have been filed. Application CA number 23 and 24 was ours. And if your lordship would like to see the particular application, I have put them in my SLP.
Mr. Shubhro Prakash Lahiri.
Lordship, please. Shubhro Prakash Lahiri was our advocate there. We got notice, Milord. Your Lordship will see the third last line of that para. That notice was December 6, 2023.
But you never said that, well, if this is cancelled, allow us to retain our lien on our earlier employment.
So, Milord, I am putting it this way, Milord.
Your case was of segregation.
Yes, and I am nowhere in any CBI list. In any list, Milord, I am not there. I have been given continuity.
Let me come back after that.